Uh, Good evening to one and all present here. On behalf of management of St.Mother Engineering College, its principal, HOD, staff and students, I welcome everybody for this webinar. Today we are having a webinar session with Dr. Mahendra Kumar sir. It is about intellectual property rights. Actually, Vinod Kumar sir is a professor in biotech department of Guru Nanak College Autonomous Vedacheri. He is actually a rank holder, a university rank holder and gold medalist during his post graduation. He has cleared the Tamil Nadu state eligibility test TN set of government of Tamil Nadu in 2016. Further, he completed his PhD degree in the year 2016, and he is the convener of Guru Nanak College in Institution Innovation Council and a well-known innovation ambassador, and he is the member of IPR cell of the college. So he has published 15 research papers in high impact factor journals. Further, he is having 5 patents to his credits. He has won several awards. Particularly, he is a well-known personality in the field of intellectual property rights. So, on behalf of management of St. Mother Engineering College, its principal, HOD, staff and students, I welcome you, sir. I directly hand over the session to you, sir. So, thank you so much.
Thank you. Thank you very much, sir, for the warm words of introduction and welcome. Present my screen. So is my screen visible? Thank you. Thank you very much, sir. Welcome, dear participants, for this webinar on role of intellectual property rights in economic growth, organized by the Department of Electrical and Electronics Engineering and Mother Teresa Engineering College, Tuticorin. Before going to the topic, I just want to tell you the very narrow difference between what is a discovery, an invention, and an innovation. Discovery is something which is already existing in nature that we find either wantedly or without any necessity. But an invention is totally different. Invention is something which we create for our necessity or our needs or to fulfill our basic requirements. We create something. So that is called invention. If you do a multi-purpose invention, then it becomes innovation. So one product, too many uses is innovation. And why we talk about innovation here? Because when you innovate, it becomes more useful. And that usefulness can be converted into a patent. So directly going to the topic, intellectual property rights. These rights are associated with the property called intellectual property, and this intellectual property comes under property. So property means you all know which we own. Something we own is called property. And this property, what we own, is of two types. One is tangible property or measurable property. Example, your movable and immovable properties like vehicle, jewels, land, cash, buildings, etc. There is another type of property that is called intangible property, which is also known as not measurable or immeasurable property. So our intellectual property comes under this intangible property. Literally, this means you cannot touch, you cannot see, but it exists. And the major difference between tangible and intangible property are tangible property have present value. You can easily liquidate it into cash, but the value of tangible property depreciates day by day. Whereas intangible property, it grows. The value of intangible property appreciates every day. And intellectual property is again divided into two. That is industrial property, which consists of patents, designs, trademarks, geographical indications, etc. And the other major division is copyrights. So we'll quickly see about each and every intellectual property right. And I have prepared this presentation more giving weightage to patents and how it can be converted into in economic prosperity. And why we are talking about this IPR? What is the purpose of this intellectual property right? The basic purpose is to recognize and reward original effort and also to protect such original effort from wrongful use. It is an undisputed fact that unless we reward original thinkers or creators and protect their rights over their infringement, society will suffer and people will go back. They will not do any kind of research and technological progress will be seriously affected. And that's why we need to protect the intellectual property. And what is the significance? Intellectual property are today's monetary engines that are generating fortunes for companies and countries. And intellectual property avoids duplication of research. Once it is published, you cannot copy that. It also helps industry to produce better and cheaper products by innovation. We all know China is a far bigger country in manufacturing. Every product we take, China is leading. India has more engineers. There are more resources in Africa. Russia has more natural gas and oil. That's why we now facing the Ukraine-Russia war. But still, USA is richer. Why? Because they know how to protect their intellectual property. Every entity, every company in US runs on their patents, runs on their intellectual property rights. So every time we buy a mobile in India, or in any other country, anybody watches a movie, they search something online, entities from the USA earn money through their intellectual property. And the types of property, intellectual property are patents, copyrights, trademarks, trade secrets, geographical indications, industrial designs, plant varieties. So one may think, so to create or to generate or to have intellectual property, should I work more? Yes, you have to work more. But if you work smart, you can have too many intellectual property in one product. Like in this particular phone, the data processing methods, operating systems, operation of user interface, everything protected by patents. The overall look of the phone, how the buttons are arranged, what are the shape of the button, what is the position of the screen. So that is protected by design. And there will be some technical know-how which is not revealed usually, which will be kept in-house, are called trade secrets. And the software inside the phone on which the phone works, the user manual which is given along with the phone, the ringtones, startup tones, and the built-in images are protected by copyright. And the name, the logo, everything are protected by trademark. So by creating one particular product, you can enjoy 5 intellectual property rights or even more than that. Now, since this is an engineering institution, I have concentrated very few slides on how intellectual property can play an important role in engineering institutions. We all know engineering institutions are the hub of research and development activity that have huge potential for creating new intellectual property. Hence, a basic understanding of the themes and types of intellectual property is a must for every stakeholder, faculty, student, researchers, and R&D units. How intellectual property rights can be useful for the engineers. The knowledge of intellectual property adds tremendous monetary value to them. It enables you to improve the quality, opens up a world of new acquired opportunities, has special value for qualified engineers in terms of consultancy promotion. Even when if you join a company as an employee, or tomorrow you start your own company as an entrepreneur, the role of intellectual property rights adds tremendous value. As an engineer, you may have an idea to improve something already existing. There is a machine you see, whichever machine you see, you want to improve. If you feel there is a scope of improvement, you can do that, and by that you can increase the production, and which will affect the price of goods. It can lead to significant technological advantages also, like making the goods globally competitive and help you earn more foreign exchange. Hence, it is very important for engineers and engineering students to understand the immense value of their ideas. The ideas are not ideas, it is money minting machines, provided the ideas are supported by scientific interventions and you know how to protect them and how they can be important in changing the lives of you and that of your employees. In India, the intellectual property rights are governed by these laws: Copyright Act 1957, the Patent Act 1970, Trademark Act 1999, Geographical Indications Act 1999, Industrial Designs Act 2000, the Protection of Plant Varieties and Farmers' Rights Act 2001, and last, the Biological Diversity Act 2002. So, copyright, most of you would have heard about this. Whenever you open a book, the first few pages, you can see something like this. The book material is copyrighted. No part of the book or full or part of the book can be reproduced, copied without the permission of the copyright author or the owner. So this is nothing but an exclusive right given to the owner for his literary artistic creations, such as poem, novel, music, paintings, cinematographic works, architectural works, sculptures, TV and radio broadcast, and many other. There is no formal registration required for copyrights, but if you register, the value is more, and it will give you a lot of monetary benefits. Like if you become the copyright owner, that is, you copyright your work, what you can do or what are the privileges you will get. You can prohibit others or you can authorize others to copy or reproduce your work. You can distribute it to the public in copy format. You can perform or you can allow others to perform in public, or you can allow or permit others to broadcast or used online in return of money, or you can allow others to translate your work into other languages. But there is only one limitation: fair use for personal and educational purpose. In case you are using a copyrighted material for personal or educational purpose, then the copyright infringement will not affect you. But in case if it is proved that you are exploiting other copyrighted material for money, then you will be sued. Next is industrial design. This refers to the right granted in many countries to protect the original ornamental aesthetic feature. Like the basic difference between patent and designs are now I'm like, whenever I hear people telling design patent, there is nothing called design patent. We have utility patent, we have process patent, we have product patent, but there is nothing called design patent. It is called designs. And the basic difference between a design and a patent is both are associated with the product, but in case your intellectual property rights governs the working of the product, how better the product is, how useful the product is, how it is different from other products in terms of its usage, then it is governed by patent. But how the product looks, irrespective whether it is useful or it is not useful, how it is used, that matters. And that aesthetic feature or ornamental feature is industrial designs. Now comes the patent. Patent is an intellectual property right granted to an inventor by any country's government. It is not country specific. Any country's government, you can apply your patent in any country, whichever you feel you may earn money, and usually it is given for 20 years. And it is a territorial right. What I mean by territorial right? When you file a patent and get it granted in a particular country, the patent is valid only in that particular country. There is nothing called international patents. Like sitting in India, you cannot apply a patent which is valid throughout the world. No. In case you want to protect your rights in your invention in United States, you have to file in a separate application in the United States and you have to get a US patent. In case you want to protect your invention in Australia, you have to get an Australian patent. Either Japan, Singapore, Germany, China, any country for that matter, if you feel your invention has very good scope in that particular country, then you can very well file an application and get your invention protected by their patent law. There is, for this particular purpose, the governments, all the countries' government, they have spoke, they have argued, they have agreed finally to something called Patent Cooperation Treaty, where by sitting in one country, when you make the PCT application, you need not go to any other country, but you will get patent in all the country using this PCT. This gives the owner an exclusive monopoly right. That means what? You can prohibit anybody from from using your work. Only if you authorize, they'll be able to use it. If you don't authorize, they won't be able to use it. In case they use it, you can put them in, you can get them nice punishment and penalty. It is treated as a valuable property which can be inherited, gifted, sold, or licensed on agreements. Like any other, I have a bike, I have a car, I can sell it, I can gift it to some of my relative or friend, or I can sell it, or I can give it for, if a house, if a father dies, automatically the house is, house will come to his legal heirs, wife or the children. Like that, patent also can be inherited to your legal heirs. It can be gifted by anybody to anybody. It can be sold, or it can be given on license. So for 3 years, you use my patent. You do business, you get money, you give me money. That is the concept. So how this process of or word patent or the concept of patent came in India? It is from time immemorial. People, think innovative. They produce product innovative, in an innovative manner. But it was in 1856 when the British government felt that something like, we should create some policy, some rule for protection of the inventors, because that was the time when industrial revolution kicked off. So each and every country wanted to prove their supremacy over the other in terms of inventions. So the government of Britain, they passed this British Patent Law of 1852. Then it changed as 1856 Act 6, which is called, or which has given certain privileges to the inventor of new manufacturers for 14 years. After 3 years, the same act was modified and called as Exclusive Privileges Act, which is given for again 14 years. In 1872, the same thing was upgraded or renamed as Patents and it's not patent, it's Patent and Designs Protection Act. Then after 5 years, it is renamed as Protections of Inventions Act. Then in 1888, finally it was consolidated as Inventions and Designs Act of the Britain. Then in 1911, till 1911, it was a single law of the Britain, which was applicable to all the colonies of Britain. Wherever British was ruling, it was applicable. But in 1911, Britain felt that the Indian inventors need a specific or a separate act, which will be applicable only in India. So in 1911, the Indian Patent Designs Act was passed, and it was in practice even after independence. So finally, after independence, we formed committees, we prioritized. Finally, we formed a committee which has framed as the Patent Act 1970, and in 1970 this was enacted. So this even now, it's been nearly 52 years, but even now the same 1970 Patent Act holds good. In compliance of the international agreements, this 1970 Patent Act was amended, was changed many a times in 1972, 1999, 2003, 2005, and 2015, and very late in 2018. And these amendments, why they are doing? We are party to several agreements of the international bodies like UNO, TRIPS, GATT. So whenever they take some decision, we have to incorporate those decisions, or we have to follow those in our country, and that can be done only by amending our patent law. So finally, this Patent Act, the important feature of Patent Act is it clearly tells us what are patentable inventions and what are non-patentable inventions. I just told invention can be converted into patent, but not all inventions. Yes, this invention may be useful, but it cannot be converted into a patentable invention if it falls under certain category. Let's quickly see what are those. I have an invention, I have an idea, I have converted that idea into an invention. Now the invention is ready, but will I get patent for that? So I should check whether my invention is patentable. How? To qualify for the patent protection, the invention must fulfill the so-called conditions of patentability. There is something called conditions of patentability, which includes novelty, that is newness. For the first time, it should be known to the world. Inventive step, which is like you should have done something, some step should be shown, and it should have industrial applicability or industrial utility. And finally, it should not fall under non-patentable inventions or patentable subject matter. So what are those non-patentable inventions? I just told, if your invention has to be given patent, it should be novel, it should have inventive step, it should have industrial utility. So even though your invention is unique, it is novel, it has inventive step, it has very good industrial applicability, if it falls the criteria under Section 3 and Section 4 of the Patent Act 1970, patent will not be given. So Section 3 and Section 4 of the Patent Act 1970 clearly tells about what are non-patentable inventions. So this is subdivided into from Section 3A to Section 3P. So what is Section 3A? It's called frivolous invention. An invention that is frivolous, which claims anything obviously contrary to an established fact. For example, every machine will give you only 100% efficiency. But when you say, I have produced a machine which is giving more than 100% efficiency, maybe it is useful, maybe it is, it will be very helpful for your business or your company, but patent will not be given because it is against the established fact. Then, inventions which are contrary or law of mortality or injurious to public health. So if you're going to invent something which has no death, which has no mortality, or you create some disease in a particular organism, those will not be given patent. Then Section 3, mere discovery of a scientific principle or formulation of an abstract or theory, discovery of any living thing or non-living thing substance occurring in nature, it is not patentable. So whichever is occurring in nature, it is not patentable because it is not novel or it will not have any inventive step. In Section 3D, mere discovery of a new form of a known substance or mere discovery of any new use of a known substance, process, machine, apparatus, unless such known process results in a new product or employs at least one new reactant, it will not be given patented. But if you improvise, you do a modification you do a chemical modification like adenylation, removal of benzene group, benzylation, anything, you do an extra effort, which if it increases the efficacy of the product, then you can apply for patent. Section 3 is E, tells very clearly that a substance obtained by mere admixture resulting only in the aggregation of properties of a component thereof or a process for producing such substance is not invention. For example, we all know salt is sodium chloride. Sodium is made up of sodium plus chloride. Sodium is a separate chemical, chloride is a separate chemical. When sodium and chloride mix together, it's called sodium chloride and a salt results. So here, when you add two known complex, when you add two different compound, the new resulting compound will be having properties which are amalgamated from the both. So in that case, they will not give you patent. Then Section 3F, mere arrangement or rearrangement of known devices will not give you patent. So in this picture, you can see an umbrella fitted with a fan and a torch fitted with a light. It is useful. It is novel maybe, but they will not give you patent because you have not invented anything. You have just fitted a fan inside an umbrella. You have just fitted a light on top of a cap. So this may be useful. You can produce, you can make money, but you cannot stop others from copying it because it cannot be patented. In section 3H, method of agriculture or horticulture cannot be patented. But agriculture, equipments which will help you to will do more good agriculture, it is patented. In section 3I, any process for the medicinal, surgical, curative, prophylactic, diagnostic, therapeutic, or anything related to treatment of animals, it is not patented. It is, you can use it, but you cannot stop others from using it, because these are all directly linked with lives. Section 3J, plant and animals in whole or there, any part thereof or other microorganism other than microorganisms are not patented. Even microorganisms also were not patented earlier, but our own Indian, who is now, who was converted into an American, Anand C. Chakrabarti. So he tried and he fought in the court, and he has produced something called superbugs, which are nothing but Pseudomonas species of microorganism that had cleared the oil spills when any shipwreck or any accident happens in the ocean. This organism helps in the easy oil spilling, clearing of the oil spilling. So the microorganisms were granted patent. Then section 3K tells very clearly that any mathematical or a business method or a computer program per se or algorithms are not inventions, hence are not patentable. But these software programs are can be protected under copyright. Even that is also an intellectual property. You can earn money, but it cannot be patented. In section 3L, any literary, artistic, dramatic, musical work or any aesthetic creation whatsoever, including cinematographic work, television productions, comes under Copyright Act 1957 protection, and it is therefore left out of the purviews of Patent Act. Then section 3M, a mere scheme or rule or method of performing mental act or method of playing game is not patentable. So like if you use some tricks in playing a game, like maybe a chess or carom, you use a trick, maybe you will win, you will get more money, in particular if it is like, if it is, if it is like played for competition, but it cannot be patented. Section 3N, a presentation of information in any manner, method, spoken words, display, diagram, symbols are not protected, because something like the diagram symbols are protected by Trademark Act 1999. Then section 3O, the topography of ICs. Most of you are engineering students, you know what is integrated circuits. So it is protected by something called Semiconductor Integrated Circuit Designs, Layout Designs Act, and not by Patent Act. Then last, any invention which is in effect, which is traditional knowledge involved, like the particular knowledge of a tribe or a particular group having some traditional knowledge, it cannot be patented. Next section is section 4. There is only one point in section 4. That is, any invention relating to atomic energy is not patentable. How better it is, how useful it is, how unique it is not patentable as per section 21 of the Atomic Energy Act 1962. So this says very clearly that no patent shall be granted for invention which in the opinion of central government are useful for or relating to the production, control, use or disposal of atomic energy, or the prospecting, mining, extraction, production, physical and chemical treatment, fabrication, enrichment, canning and usefulness of any prescribed substance. If it is atomic energy involved or radio substance involved, it cannot be patented. Right. Now, I have an idea which is not falling under any of the sections 3 and 4. It is unique, it is having novelty, it is the industrial applicability, and it is very unique. So it is not coming under section 3 and section 4 means you can directly file a patent application. And the application which you're filing can be either provisional or can be complete. So provisional means you will not give much information. You will just tell title of the invention, inventor's details, that's all. But whereas a complete application involves all details, every specification, every diagrams, everything that is related to your invention should be given, because based upon that only your application will be processed. Either it will win or it may lose based upon the information you are providing in the complete application. So once you file, within 18 months, your application will be published in the Gazette of the Indian Patent Office. Then you have to request for examination. So then from the date of filing, within 48 months, the request for examination can happen. And after once you request, the patent examiner will issue the FER. What is FER? First examination report. So this can be either grant of patent if there is no objections received, but if opposition is received, then the decision of the controller is final. But even after that, even after he says either he gives a patent or he says no to the patent because of the opposition, the bereaved party can go to the appeal to the appellate board, and the decision of the appellate board is final, which can be either revocation of patent, there is cancellation of patent, or they say only this part is being given any opposition, so you change this particular area. So that is called amendment of patent. In case the appeal is of no use, then they will dismiss the appeal also. So I told patents are filed only in India, or whichever country it is you're coming from. But in case you want to, if you have found out some invention which are very, very useful in many countries, then you want to protect your invention in many countries, how you can do that? You can do using the Patent Cooperation Treaty. So many company startups operating from India cater to the foreign markets, especially USA. We do outsourcing. So hence such companies are keen on filing international patent outside. So such companies, startups generally complete adopting the following option. You have to file something called PCT application. So once you do that, it can reach you or it can fetch you protection in so many countries you wanted protection. So before filing, it is always better to search if a similar work is already published or already filed patent. Because if something is published or filed as patent, you will fail the novelty test. Because novelty test, it should be for the first time. Whenever somebody hears that, then only they should know. Because when you tell about your idea, people should not tell that I already know it or I have seen, I have read somewhere. No, they should be telling what is this. The first time they should hear. That kind of thing is required for the successful grant of patent. So for that, these tools will help us. Google Patent Search, Advanced Google Patent Search, Indian Patent Office Search, USPTO Search, Espacenet, Quastel, Patent Scope, and Free Patents Online. So these softwares or websites you can use for searching your similar patents, so that you can change your patent and file. So what are the job opportunities that are there in this particular patents? Because I thought it will help. So how IP functions for marketing? So far we said it is a scientist job who will invent something, spending more time on it, and he gets a patent. So normally scientists only get patent, but the patent can be made into a tool of earning money, or it can function as a marketing tool of a company. By how? Function of disclosing corporate strategy like IP, especially patent information, indicates corporate information including R&D strategies as well as business strategies on potential market to enter the near future. So somebody is coming and telling you, we need a strategy roadmap. With this amount of patent we have, we want to move further. We want to be, we want to enter the big market. So their IP is very, very useful. Function of deterring market entry. You can stop others from entering the market. Example, Xerox World. The first copier using plain paper. Now we call it as Xerox machine. Actually, it is called photocopier, but we call it as Xerox machine. So the name Xerox, the company, has gone into our minds, and we have started forgetting that the process is called photocopy. Instead, we say it is Xeroxing. So that is the power of patent. The Xerox company had the patent on the first copier, so that without using Xerox, you cannot use that particular machine. Then number third, function of exclusion from the market. So in case somebody is going to copy and you find it, they'll be sent out of the market. their reputation will be down. So patent, again, it is very much useful to exclude the infringers or people with bad intention. The last is function of building business partnership. So only when you have so much number of patents, you can have a very good relationship between other companies, and they'll also respect you and they'll also collaborate with you. If you don't have patents, then they may not be of any usefulness to you. So this IPR is definitely a recession-proof career, because you see, when now and then IT people say it's a recession for them, lot of layoffs. Many people, as you grow up the ladder, you're sent out. So one who has served IT companies for 5 years or 10 years, once they go as a bigger uh, to positions, they are sent out, because the same amount they can give it to more than two or three people, which is being given to them. So, but it is for normal career. But for IPR, if you become an IP expert, or if you have a career in IPR, then you can very confidently say that I'm in a recession-proof career. There will be no recession affecting the IPR. And it is, if you ask me, is IP a good career choice? Yes, it is a good career choice. In the current global or country specific environment, yes, it is. Because why? Innovations and inventions are part of the human development, and therefore, experts will always be needed to protect the ideas and ownership of invention. Next is patent legal process outsourcing. We have something called, we would have heard about BPO, business processing outsourcing. We would have heard about KPOs, knowledge process outsourcing. Now we have something called patent legal process outsourcing, that is called LPO, because the cost of preparing, filing, prosecuting, maintaining patents have become extremely high in the Western world, because they earn, just a minute. Ma'am, sorry, sir, I had some network issue. Yes. So these LPOs are a very good source of income, and people are minting money, if you believe. No, those who be sitting in India, people are working for the Western country, and it is not a time bound. You can take your own time. And if you have some knowledge in intellectual property rights, or if you finish some courses, there are a lot of free courses in the WIPO, that is World Intellectual Property Organization. They give a lot of free courses. They have paid courses also. You have courses in Udemy, you have courses, a lot of MOOC courses are there for intellectual property rights. If you finish those certifications, you are the hot cake in today's market. And what do you get by that? You will get an opportunity by this intellectual property to work for companies like Fortune 500 companies. And India and the entire world is now waking up to the potential of intellectual property, and a career in intellectual property is now very sought after. With India becoming a hub of startups, R&D centers, because we have so many schemes like Make in India, Startup India, Stand Up India. So with these very good schemes for entrepreneurs or startup people, it is very much essential to protect your ideas, because startups can be financed, can be given money only by their ideas. And for that, you need to protect your ideas. If you fail protecting your ideas, then it is of no use, because somebody who may like listen to your ideas, if you don't protect your ideas, then he may easily execute it and you'll be a failure. So the importance of protecting your intellectual property. It is as important as your thinking, is as important as your thoughts. Just thinking novel or thinking innovativeness is not tall enough. You have to know how to protect that. And now, I hope most of the students are engineering based students or science based students. Hence, I want to tell you about this Indian Patent Agent exam. This is exam which is conducted by the Indian Patent Office, Ministry of Trade and Commerce. So, who are these patent agents? The patent agents are persons who are qualified to prosecute patents. What is prosecution of patents? Drafting a patent application and filing the application in the patent office. Yes, we have e-filing now, but even that you need a skill how to draft an application, because even though your ideas are very novel, if you fail to draft it properly, you may lose it to others. So patent drafting is very, very important, and these people, patent agents, helps us in drafting our patent applications, conversion of our ideas into a protective item, and this requires specific technical knowledge as well as legal knowledge. So without you being a qualified person, you won't be able to do that successfully. So a patent can be prosecuted in India. A patent can be prosecuted through a registered patent agent as per section 126, which tells the qualifications on becoming a patent agent. So the statutory requirements for becoming a patent agent are: you should be a citizen of India who have completed age of 21 years. You should have obtained a degree in science or engineering or technology from any university established under law for the time being in force in the territory of India. You should have passed a qualifying after finishing your degree. If your degree is either BSc, BTech or BE, basic degrees, that science, engineering, technology, you can apply for this exam, and you should write the exam and you should pass the exam. And the patent agent exam is just the qualifying exam, which is conducted by the Controller General of Patent under the Ministry of Trade and Commerce. So passing this exam is a must in order to qualify as a registered Indian patent agent. So before proceeding the listed qualities, two things are very clear. If you want to become a patent agent, a degree in law is not at all required. Don't think that patents can be prosecuted only by patent attorneys. No. If you're a lawyer, you can call yourself as an attorney, no doubt. But it is not mandatory that only a law degree is required to do. Even as science, engineering degree can also be possible if you clear this patent agent exam. And an individual with the degree in law does not automatically qualify as patent agent unless you meet the requirements. You have to pass the exam. So what are the advantages of becoming a patent agent? You get certification by the Indian Patent Office. Your name will be listed in their patent office website as registered patent agents, so that people can easily contact you. You can work either as independent consultant having your own company, or you can work in MNCs, law firms, IP companies for patent filing, drafting, working in coordination with the patent agent office. For example, we have some more careers like patent analyst, patent managers. So once every MNCs are having patents and they run only by patents. And if they have any patent problem in any patent, these patent agents will help them. So we can join any company as a patent agent also. Or during amalgamation, during merge of two companies, when you value a particular company, their assets will be evaluated. Likewise, their patents also will be, their intellectual properties will also be evaluated. And to evaluate that, you need patent agents. So they are called patent evaluators. So these are the top institutes in India offering intellectual property courses. You can either, you can join them as full-time, or we have online courses also. I mean, you have distance education courses also. And now SWAYAM, NPTEL, all MOOC courses. There are a lot of courses related to intellectual property rights, which are very, very useful and which can be, exploited. So this is the website of ipindia.nic.in, the Intellectual Property India website. This is a very, very user-friendly website, interactive website, which will give you all information about the intellectual property and its rights in Indian territory. So thank you very much. I would like to thank the director, principal, head, and faculty members of the Department of Electrical and Electronics Engineering, St.Mother Teresa Engineering College, Tuticorin, for giving me an opportunity to share my ideas on IPR. I would also like to thank Professor Ayyappa Srinivasan, Coordinator EDC, St. Mother Teresa Engineering College, for the invitation and the conduct of this webinar. I would also like to thank my college General Secretary and Correspondent Principal, Vice Principal for always motivating me in all my academic careers. And last but not the least, dear participants, for your patient listening. So now I would be more happy if I get more questions so that I can clarify with my knowledge on intellectual property. Thank you. Thank you. Thank you very much, sir. Yes, sir. If there are no questions, we can wind up. Thank you, sir. Yes, sir. Why not? We'll discuss, sir. Sure, sir. Sir, and also like last week, I've been given a certification as IPR trainer by the patent office for NIPAM program. Yes, sir. We will discuss. We will discuss. Thank you. Thank you all participants for your patient listening.